Thank you so much for the presentation. It's an honor to have you here in our law firm. In Brazil, we do have protection for trade secrets, of course, in our industrial property law, but we don't have a directive as you have in the European Union with all these details of so many situations and the specifications. And for this reason, many times the terms of the agreement are really crucial for protection of the know-how that is being transferred. And we've had some years ago a very interesting case in which we had a German client actually who executed an agreement for license of know-how with a Turkish company. And the agreement expired. The Turkish, they paid for the technology, but it was very specific. The agreement was very specific for the license of one plant, for construction of one plant in Turkey. So it was clear about that. There was no authorization for use of the trade secrets outside Turkey, and for construction of another plant, there were lots of limitations in the agreement. And then the Brazilian subsidiary of the German client became aware that a plant was being constructed in Bahia. And they really had suspicions that the know-how was being used here. We were actually consulted for a second opinion. The client really wanted to take action, and I saw this because we didn't have much, we didn't have evidence. We had actually suspicions at that time, but I said, I'm not the one who will say they can do nothing, because there was a clear violation of the terms of the agreement between the German company and the Turkish one. And then we actually helped the client to build the case for Brazil, to get evidence. We filed a search and seizure in Bahia, also a criminal action. We had three lawsuits for this. And the agreement, the case was recently ruled. It lasted for a decade. In the second lawsuit that we filed, we requested a preliminary injunction for the plant not to open in Bahia, and it was granted, because in the search and seizure, we could obtain documents evidencing the transfer between the German and the Turkish. It was a total surprise for them. They would never expect this. And then we had material. We got expert opinions and many things. And we obtained the preliminary injunction. We were able actually to postpone the opening of the plant for about 5 years, which is a lot, because the equipment, after a while, the judge said, for public interest, because of the employment, positions, taxes, and many things, I will let the plant open. But the fact was that the equipment was old, it was no longer state-of-the-art technology, and then it was a very successful case. It's still in the Superior Court of Justice here. Actually, they have a deadline to file. We believe they will file. We've had about 10 days ago, a decision saying that, because we appealed when the decision said, the first instance decision said that the plant could open, we appealed this, and then we've had a second instance, a decision from the court saying that there was actual violation of the trade secret that was transferred. So the client is able to require an indemnification. It was a very successful and challenging case, and now we are waiting for the final developments, but it was a very emblematic case under Brazilian law, I would say. So I wanted to mention it to you, and I think we can now open for questions.
Yeah. Thank you, Cândida.